Welcome, everyone. My name is Jeff Eisenach. I'm a non-resident senior fellow here at the American Enterprise Institute. It's a pleasure to welcome all of the people here in the room today, as well as a lot of people I know are participating online, to our little symposium on the proposed revisions to the merger guidelines. I want to credit Bill Baer, one of our speakers on the next panel, for pointing out that our conference is mistitled. They are no longer horizontal merger guidelines. They are actually just merger guidelines covering both horizontal and vertical mergers. And one of the topics of debate is whether that's a good idea, but I don't know if we'll get to that today. We will get to lots of other aspects of the future of merger review policy and the impact of the proposed revised guidelines on that. The original merger guidelines were issued in 1968, happily as an economist, authored by an economist, Don Turner, who was running, also a lawyer at the antitrust division at that time. Revisions issued in 82 by Bill Baxter, 84, 92, 97, 2010, and proposed revisions issued in July of this year and put out for public comment 60 days ago. Public comments were due to the agencies yesterday. As of this morning, they were still coming in, and there were 1,497 comments as of about 11:50 this morning. For those who are at the agencies and responsible for reading all these comments, it may seem like a lot, but I'd like to give you the good news. It pales in comparison with the 21.7 million comments submitted to the Federal Communications Commission in 2017, when Ajit Pai proposed and ultimately did repeal the Obama administration's net neutrality rules. There's more good news. My random sample of the comments on the draft guidelines indicates that they are laced with far fewer expletives than the ones received on net neutrality in 2017. So while antitrust is perhaps a more contentious topic than it has been in the recent past, the debate over antitrust policy remains civilized by modern standards. So how should we think about the new guidelines and where we're going to go from here? That's the topic of today's conference. And I'll just throw out this thought. A certain former FTC chairman who's in the room with us today gave a talk on the 20th anniversary of the 1982 merger guideline revisions, and suggested that the guidelines, so this was in 2002, commenting on the 1982 revisions, and Tim Muris, who, as I say, is here, suggested that the 82 revisions had demonstrated the importance of three lessons: the benefits of transparency, providing parties, interested parties, some guidance about how mergers would be assessed. Secondly, the role of self-limiting principles, the notion that the agencies would constrain themselves to an established set of criteria and not make things up as they went along. And then third, the power of ideas, the role that the guidelines had played, the 82 guidelines had played in influencing modern antitrust jurisprudence. So I want to suggest that those are three useful criteria, not the only ones, but three useful criteria for thinking about the new guidelines. Will they prove transparent in the sense of meaningfully informing potential participants in future transactions about the criteria that will apply, or, as some people are suggested, are the 13 principles enunciated in the draft guidelines more analogous to the 15 Georgia-Pacific principles, which, for those familiar with patent law, have not generally been regarded as particularly well-defined. Secondly, will the new guidelines prove self-limiting in the sense of imposing meaningful limits on agency discretion? And third, and this is very much in keeping with AEI's motto, competition in the market for ideas is essential for a free society. Will the new guidelines meet that test and prove to have the enduring impact on antitrust jurisprudence that most people would attribute to the prior rounds of revisions over the past 55 years, all told? Now, consistent with that last thought, we have a diverse group of panelists today, speakers. You're going to hear as much disagreement as agreement, and we think that's a healthy thing. In an hour or so, I will moderate a panel of distinguished antitrust attorneys. But first, my AEI colleague, Dr. Mark Jamison, will lead a group of economists. Mark is a non-resident senior fellow at AEI, a professor at the University of Florida. Congrats on the Tennessee win. Big deal. That was a good game to watch. And also the director of the university's public utility research center. So, Mark, I'll turn the floor over to you.
All right. Thank you very much, Jeff. And thank you all for being here. We have to discuss the economics of what happens next with respect to merger guidelines. Four distinguished economists. I will introduce them, and then we'll get into our discussion. Joining us today is Bruce Kobayashi. He's the Page V. and Henry N. Butler Chair in Law and Economics at the Antonin Scalia Law School at George Mason University. Bruce was director of the Federal Trade Commission's Bureau of Economics and worked on the 2020 vertical merger guidelines. Also joining us today is Robert Kulik. He's a visiting scholar also at the American Enterprise Institute, very well known for his antitrust work, his extensive publications and such, so he's well regarded, well known in this particular field. Then also joining us is Aviv Nevo. He is the current director of the Bureau of Economics at the FTC. He's on leave from his chair in the economics department at the University of Pennsylvania. And then also joining us via video is Carl Shapiro. Carl's a professor at the University of California, Berkeley, Haas School of Business. He served on the Obama administration's Council of Economic Advisors and also was the Deputy Assistant Attorney General for Economics in the Antitrust Division of the Department of Justice. He contributed extensively to both the 2010 horizontal merger guidelines and the 2020 vertical merger guidelines. So Bruce, Robert, Aviv, and Carl, welcome. Thank you for joining us today. So Aviv, I'll start with you because you're in a unique chair at this moment. All the rest of us are outside the regulatory agencies. You're inside. So tell us, if you would, please, just help us lay the groundwork. Why do merger guidelines matter? And what's different with what's been proposed versus what we've had in the past?
So good afternoon. Thank you, Mark. Thank you, Jeff. Thank you, AI, for putting this together and for inviting me to speak here. Let me just get the usual disclaimer out of the way first. The comments I'm about to say are my own views and do not necessarily reflect those of the Commission or any individual commissioner. So as Jeff mentioned earlier, July 19th, the FTC and DOJ issued draft merger guidelines. We're not calling them proposed merger guidelines, they're draft merger guidelines. We had a 2-month comment period that ended yesterday. And as Jeff mentioned, we got thousands of comments and we're very grateful for it. And we're in the process of going through those comments and as well as gathering other comments as we are, as we speak on panels like this and trying to figure out what we're going to do next. So once the review process is completed, we hope to issue the merger guidelines that will replace both the 2010 horizontal merger guidelines and the 2020 vertical merger guidelines. So as kind of was mentioned earlier by Jeff, the first merger guidelines were issued in 1968, 55 years ago. I'd like to claim that I worked on them as a 3-year-old intern kindergartner, but that would be fake, so I would not say that. Overall, they've been updated periodically, and they play a very major or very important role, I think, in antitrust enforcement. I think the guidelines serve 3 primary goals. The first is they really serve as an internal reference for the staff and the leadership, right? I mean, it's a guide. I mean, and I had that. I used to work at the DOJ with my good friend Bill Baer, who's here. And now at the FTC. And in both agencies, I can tell you that when you look at a merger, you quite often go back and say, well, what do the guidelines say? Right? The own internal document, you go and use them as a reference. They're also used as line of communication between the leadership and staff of sort of saying, well, under this provision, what do we think of this merger? So that's really a very important role. Second, they're meant to inform the business and antitrust community about how the agencies evaluate mergers, all right? Just as they are used as an internal reference, others can say, okay, that's the quote-unquote manual. It's not quite a manual, but this is what the agencies follows. And I think that's important. It's important to inform the antitrust community, the lawyers and economists that are outside the agency, but I think it also works to inform the business community that interacts with those lawyers, right? They're saying, okay, you're not just making this stuff up. You can actually go and say, look, this is what the guidelines say, and these are the issues that you might or might not face if you put your deal forward. So that's the second. And then the final is they're meant to serve as a reference to help courts. Having testified myself quite a few times as an expert, I can tell you they're quite useful when you talk to a judge and you say, look, here is a reference of what I'm doing. I'm using the hypothetical monopolist test, but I did not invent this. Okay, this is something that's been used for a while. Here's a document that explains how it's used, just as a particular example, but that's other ways in which these guidelines are useful. And if you look, even though there's really they don't have any binding legal precedent, courts cite them. And based on that, it seems like courts actually find them quite useful. Okay, so those are kind of the three goals. And with that in mind, let me say a few words about the changes in these guidelines relative to the previous guidelines and try to comment. I'll do that a little bit now, and I'm sure we'll talk about it throughout the panel, how these changes serve these particular goals. So first, if all you do is you just pick up the draft guidelines and you pick up, let's say, the 2010 horizontal merger guidelines, say you don't even read them. Okay, you just look at them, they look different. They're structured differently. They have, the current ones have more footnotes. They have, or to refer to 13 different guidelines or sections. This is intentional. Okay, obviously, it was a choice, and was really meant to try to make the guidelines more readable. And more readable not just for kind of a small community that's used to reading the 2010, but to say, especially the first few pages, the introduction, you could say any, non-antitrust lawyer, general counsel, or a business person can pick it up and say, look, this is what I'm going to face if I want to propose a merger. That was the intention of trying to do that. So that's the first change. The second is that these are the first guidelines to reference case law. I think the intention here is, I think, one that we can all agree with, is to start with the law, go through some kind of basic economic principles, and then end with the practical tools. Okay, now that's a lot to deliver, but I think, in terms of a goal, I think it's a very noble goal. In practice, just based on reading commentary, there seems to be a lot of disagreement about the law. This is the economist panel, so I'm not going to sort of get into that. I'm sure the next panel is going to get into that. So I'm going to completely punt on that, but I will admit that is a change. Okay, and we can argue about, directions of it. Third, and I think something that's not very well appreciated, in part because of this kind of second point I just made, is that these guidelines have a lot more economics in them. And let me be bold and equate economics with ideas, right? So if one of the goals is to have more ideas, having more economics means we have more ideas in them. And this is needed, and why is it needed? It's needed because the modern economy is evolving. We're seeing new business patterns. We're seeing new ways in which market interacts, and we need to update our economic thinking of how to look at these. Okay? And that's a big part of what's in these guidelines. Frankly, I would have preferred that we've had more discussion on it instead of getting caught up as to talking about case law or not, but hopefully in the long run, that's what's going to happen. Another change here is that these guidelines are focused on removing labels. We already saw that a little bit actually in the introductory comment. The mere fact that we now have merger guidelines as opposed to horizontal and vertical is the, if you want, exhibit number one in supporting that claim. Why did we sort of do that? Because a labeling exercise gets in the way of substance. Okay? What we should be focusing on are the competitive effects, benefits or harm of a deal, not about trying to label them. Okay? Who cares what we call it, if we call it horizontal or vertical or some mix of the two? Okay? What we care about is the substance. Okay? And I actually have seen on firsthand on cases where labels were getting in the way of substance, and that's what we're trying to do here, among other things, just to kind of bring, here's a framework, a unified framework to look at mergers, and some mergers might raise horizontal concerns, some might raise non-horizontal concerns, you can call them vertical, you can call them other things. You want to look at them all together and weigh them all together. So that's, again, one thing that we've added here. And again, that's needed because as you go to modern markets, this kind of strict dichotomy, horizontal, vertical, just doesn't make any sense. Okay? Fifth, there's a refinement of some of the tools. We could have had a lot more discussion of these refinements. Actually, what's interesting is there hasn't been much, and I'm not sure if it's because, a lot of the commenters got distracted in other ways, or because people are actually pretty happy with what we've done. So I actually started, as comments have kind of got in, and I've noticed that some of the comments on the tools are actually quite positive. One commentator who typically tends to be quite critical, even noted the appendix where a lot of the tools are presented, literally, and I quote, is a thing of beauty. Okay, happy to show you the site. I'm probably gonna, print it, frame it, put it in my office because we need some good words these days. So some of the examples of what we've changed the way that evidence and economic evidence is presented and discussed, right? We actually said, look, there's a gradual building up of evidence, right? You can sort of learn a lot of things. You can learn stuff from documents. You can learn stuff from testimony and kind of build up. You can learn stuff from win-loss data, building up to maybe writing something like a merger simulation model, right? And the idea is to say there's a gradual learning that goes on there that tells you about the lessening of competition and trying to sort of help courts in how to, how they think about this and try to explain how the agencies look at that. We try to clarify the language of what it is that, that we should be looking at and what it is that courts should be looking at, and to not create a so-called CSI effect, which we've been seeing where courts kind of set an unrealistic expectations of what they would like to see in industries where, look, yes, I'd love to sort of present the type of evidence that we did in the Aetna case when I testified for the DOJ, but not all industries have that level of data and the ability to do that, right? So these are the type of changes that we've made. And we've also extended the discussions of theories of harm that we might consider, again, to better match modern market because there's other concerns that could arise. So those, I would say, are kind of the main changes. Let me just conclude by mentioning a couple of things that have not changed. So much has been made about the fact that we kind of dropped the term market power. Okay, and there's used to be a sentence sort of or a paragraph in the beginning of 2010 talking about the unifying theme, and that is no longer there. That's been read together maybe with some other things as saying, oh, we're completely changing the objective of antitrust because we're focusing now on a lessening of competition. And because we dropped that sentence, we're trying to say that that means something different. Okay, I personally don't think that's the case. I will acknowledge, though, people are reading it that way, so it's our job to clarify, okay, and hopefully we will, okay? The way I see it, any mergers that lessen competition deprives consumers, or more broadly, trading partners, to include, sellers or workers, the benefits of competition, okay? What are those benefits? They're lower prices, they're more choices, they're more variety, they're higher quality, innovation, if we're talking about consumers. It's higher wages, better job opportunities, and employment terms if we're talking about workers, okay? So when we're talking about a lessening of competition, that's what's being lost. There's no change, as far as I'm concerned, in the objective function, okay? Clearly, given the reaction, that is maybe not come clear, was not clear in the draft, and hopefully the final version will clarify any misunderstanding. Similarly, and somewhat kind of going along with that, there are claims that these guidelines focus more on structure. Okay, I can see why it's read maybe that way. Okay, again, it's one of these, you put a document aside for a while, you get other comments. I can see why people read what it is, but I think it's mostly a drafting issue. Okay, so for example, guideline 1, the one that talks about the structural presumption, it follows almost exactly, yes, it lowers the thresholds, okay, but it follows almost exactly what was in 2010. Now, we omitted, some language there about, rebuttal, that it's a rebuttable presumption. But again, that's a drafting issue that I'm sure will be corrected. Okay? There's maybe a few other references to structure, but again, we'll see sort of how things evolve. In my view, all this view of like axis focus on structural, I think will be taken care of in the final version, but let's see what ends up coming out. So thank you.
All right, thank you, Aviv. And I appreciate your not getting into the legal issues, because I'm sure the law panel will never discuss the economic issues. Yeah. So let me turn to Carl now. So Carl, you've been involved in merger guidelines. You've been one of the world's leading thinkers on antitrust and mergers. As you look at what has been drafted now versus where we've been before, what are your thoughts on the differences? And then you've been involved in a lot of discussions. What do you see other people saying about this?
Thanks, Mark. Hi, everybody. Sorry I can't be with you, but I'm happily here in California. I first want to thank Aviv for both being here and working on this. This is not an easy environment these days for economists to be effective. And I would say the same for Susan Athey, who's the chief economist at the Antitrust Division. So thanks to both of them from the economics profession. I would also just say, I've been pushing for many years for stronger enforcement of horizontal mergers, testified numerous times for the government, written about this. So I'm looking, that's what we were trying to do in 2010 when we revised the guidelines. So I'm evaluating these on the horizontal side, and I believe that's what the agencies are trying to do as well, whether they're going to be effective at that. And I'm quite concerned they're not going to be effective, in fact, could be counterproductive, hence my comments. I have recommendations I've made public that are on my website at UC Berkeley. So I think as to frame the discussion and pick up on what Aviv said, I would start by just clarifying for everybody, as Mark said, these guidelines will replace the 2010 horizontals and the 2020 verticals. Those are very different creatures, okay? The horizontal merger guidelines are the ones going back to 68, had been enormously influential over the years and very well established, and that's what we revised in 2010. The vertical merger guidelines from 2020, much less influential, much more controversial, so we're kind of replacing both. And I think you want to think very differently about horizontal and vertical. And I disagree with Aviv about his point about labels. Fact is, horizontal mergers are fundamentally different than vertical or non-horizontal mergers. Horizontal mergers combine competitors who are selling substitutes. That's different than combining firms that are selling complements. Very fundamental sign difference for the economist, and failure to recognize that, I think, is problematic or build on that. So in terms of what they're doing and the impact, again, to be brief here, and then we'll engage with others. Let me talk about what we did in 2010, how it compares with what I see that's happening here. The way I think about guidelines, and Mark, you mentioned this, is first, and Aviv too. First, you want to describe from the agency's point of view how you're actually evaluating mergers so the public can know. So it needs to be accurate. That's transparency. I presume this is accurate about what the current agencies want to do. Okay, what we wrote in 2010 was accurate, updated things because practice had changed. And that's one reason we raised the concentration thresholds, the HHI thresholds, because the older ones didn't reflect actual practice. Okay, so there's transparency. Okay, I'll assume this is what they're going to do. I think it has, I'm told this has been what they're doing. Then you want to reflect new learning and experience and how the economy's changed. And Aviv said they're trying to do that. I think it's hard to do that while you place a lot of weight on the 1962 Brown shoe case that is all about shoe manufacturing, but that's what they're doing. And I think there are some nice elements here about that, such as platforms and such as how to handle platforms, multi-sided platforms. And then you want to influence the case. You want to have the guidelines it's a law enforcement exercise. Remember, this is how the agencies are going to enforce the law. So but you can influence the courts because of the agency's experience, and they get some not deference, I would say, but it's understood they have a lot of experience. So we certainly we're looking to in 2010 to move the case law in a more pro-enforcement direction, particularly regarding unilateral effects, which was not well established in the case law at the time. I wrote a paper with Howard Shalansky also on my website that shows how this has been very effective in terms of the way the cases have been decided over the last dozen years. So the current guidelines are very different in a number of respects, and as Aviv said, they're more like a legal brief. A legal brief now, it's either it's a legal brief or it's a vision statement or it's aspirational about what the agencies would like merger law to be. And I think all of that is problematic, simply because it's going to be less effective. I don't think the courts are going to take to a legal brief the way they have taken to solid, more consensus economic reasoning, which is in 2010 in particular that I'm referring to horizontal. So that's my concern, is it's a very different creature. There's a lot of good economics, as Aviv said. It's primarily in an appendix, and is therefore, the primary document, the main document is a legal brief with a bunch of aspirational views about what merger law should be. And so I don't think that's going to be effective in court. So my concern is this will weaken the agency's hand when they go to court on horizontal mergers. And then non-horizontal, completely different story. There, I think there's just that this will have some bad effects in the other way by deterring mergers that are pro-competitive. So I really would separate out horizontal and non-horizontal dramatically in terms of what I think their effects are going to be and how they compare with how the draft compares with previous guidelines. Lastly, the views I've just put forward, while not shared by of course everybody, there's a large contingent of people, I would say, who are pro-enforcement, left of center, if you will, or have served in Democratic administrations, whatever labels you want to put on it, who are expressing very similar concerns. Jonathan Baker submitted a comment on behalf of a whole group of us. I signed on to that. Michael Katz, Joe Farrell, Doug Melamed, Howard Shalansky, Andy Gavel, Rich Gilbert, Fiona Scott Morton, Herb Hovenkamp. This is quite a group of people. And then a number of those people filed individual comments. Steve Salop, for example, he wasn't with the Baker group, but also, so there's a widespread concern, especially among economists, I would say, but not just them, about whether this will be counterproductive because of the way it's been structured, in contrast to 2010 in particular.
All right, thank you, Carl. So, Bruce, you've been in Aviv's chair before, and you had the experience of working on guidelines, using guidelines. I'm going to ask you the same question I was asking Carl. What are your thoughts on the change, and how do you see the discussion going?
Well, I'm part of an institute at Scalia Law School called the Global Antitrust Institute. We filed 3 comments. We didn't cover a lot of things because they're a finite amount of time, but one of the things we didn't cover was vertical. We did cover that in the RFI comments that we put in, but I could sort of not take any blame for the 2020 vertical merger guidelines because they came out after I left. But we did work on them, and I think one of the principal things, and I thought that was really part of that draft, was that we wanted to treat all of the unilateral pricing effects together, and that included RRC, what Gopal, DeStefano and Das Pharma call LRC, which is the shifting of the demand curve, and then EDM. EDM's not an efficiency, it's a unilateral pricing effect.
Okay, and for the non-economists, what did you just say?
Elimination of double marginalization. And that really struck a chord, I think largely because the lawyers thought that would be part of the prima facie case, and they wanted it to be an efficiency. You'd treat it under HMG 10 and you would ignore it. I see a lot of that in way efficiencies are traded in the draft guidelines. But I didn't see any reference to elimination of double marginalization, and I agree with something Carl said, is that, a vertical merger is inherently different, and this is not just a label, it is that you're combining complements, right? The Cournot's 1888 famous paper is horizontal or complements, but vertical mergers often involve the combination of complements, and that causes inherent downward pricing pressure to the extent it's not achieved through some kind of contract. So, the whole point of the 2020 VMGs was to say, look, if there is a concern about competitive conduct, it's something that has been labeled raising rivals' costs. It's an internalization of a pricing externality when you now are upstream and downstream and you sell to other downstream firms. That's input foreclosure. But there's also, in those cases, going to be an incentive when you have the pricing of two complements now internalized for downward pricing pressure. And all of those things are intertwined, and you want to do them together. And I think that was sort of the unilateral pricing section of the 2020 vertical merger guidelines. I thought that was a principle of economics that was very important, and we would say that the treatment of the two, you shouldn't just assume they both exist, but the treatment should be symmetric. And so it doesn't really matter whether you put them in different guidelines or the same. I mean, I agree with Aviv that, all of the vertical mergers we had, we had insurance companies buying doctor groups, and they already have a big set of doctors groups in, and they're buying more, right? There's vertical and horizontal aspects to it. RRC is basically a horizontal competition problem. So, one of the things we thought is we'd have sort of the principles to sort of think about all of these things together. Everybody said these aren't really guidelines because they don't give any guidance. We fought hard on the econ side, and there was, a lot of distrust between the two agencies while I was there, but the economists working on the 2020 VMGs worked very well together. And that's the principle, I think, is that combining substitutes in horizontal mergers is inherently different, just in the unilateral pricing effects, than combining complements in a vertical merger. So I don't think it's whether or not you have guideline 5 on foreclosure. What I do is I would sort of try and get back to the structure where you treat all the unilateral pricing effects together. And I would toss guideline 6 into, if we're in San Francisco, it would be the Bay. But, because, I mean, they have this 50% foreclosure share. It's a naive foreclosure share, but even if you use a better one, there really isn't any structural component that either theory or empirics have identified with respect to vertical mergers and things like foreclosure shares. So I'd get rid of that. I'll say that one of our comments is on, and this will probably irritate Aviv even more, but we did a structural comment, and I always thought in these things, and I never do it, but you have to come up with a catchy line, and so I think guideline 1 is sort of the cart before the horse, and there's no horse. The way I think you do evidence-based policy is that it should be based on solid theory and solid evidence. And if you're trying to differentiate between harmful and anti-competitive mergers, differentiate those types of mergers from efficient pro-competitive mergers, you probably want to basically do it based on evidence. It's possible that the structural presumption, moving from 2,500 to 1,800. I mean, it's possible that that's going to be a useful rule that saves a lot of money and time and agency resources. It's just that it doesn't seem to be, at this stage, there's a lot of evidence that suggests that to be the case. I mean, I guess the research question, and I'll lobby Aviv too, because what you ought to do is you ought to go back and try to get at least a really large and relatively randomly selected sample of mergers, that have post-merger HHIs 2,000 and up and deltas of 200, and see, to the extent the ones that were consummated, see what happened. I mean, when I was there, you only did ones with a credible control group and the data, but in some sense, if you want to go and change those and put them in the structural presumption, I think what you'd want to see is, the overwhelming majority of those were anti-competitive. Otherwise, I would stay with the 2010 approach where, say, those mergers, you could sort of have the agency look at them and put them in a special box for likely second request and a lot of resources. But putting them in the structural presumption, which, if accepted by the courts, and Carl's point is well made that it may not be, is going to be hard for parties to overcome. And if you really sort of want to put them in the box, I think you have to be fairly confident for that to be a sensible policy to have, the large fraction of those being ones that you want to either stop or deter. I have a bunch of other stuff, but I think I'll let the panel go on.
All right, thank you, Bruce. So, Aviv, I'm going to go to Rob next, but please think about, because I'll ask you out next after talk with Rob. So the differences expressed, how do we work through those going forward? How do we resolve those kinds of differences? And then we'll have to actually characterize what they really are. So, but before that, Rob, so you've recently written a couple of papers that are relevant here. One talked about kind of what is the state of competition in the economy, and because there's debate over that, and that's been some of the foundation or the motivation for thinking differently or thinking again about merger guidelines. But then also you've talked about what's going to be the role of economics. Does it change under these different guidelines? So tell us what you found and what your thoughts are, please.
Well, thank you. So I promise this is actually going to end on a very bright note for Aviv. But of course, we have to start with the research part and the motivations. And I think that is important here, the motivations, because part of the reason that the reaction has been the way it has is because this isn't occurring in a vacuum, right? We've had a year and a half now of agency leadership talking about these guidelines. And in fact, in the press release, that introduced them, the sort of first statement was about this trend towards overconcentration, rising concentration in the economy. And agency leadership has also been extremely vocal of their view that mergers have been generally harmful for the economy, and in particular, harmful for innovation. And one thing that has been a major focus, especially I think for Commissioner Slaughter, has been this idea that when we want to look at harm to innovation, it needs to be done not at the market level, but at the industry level, because somehow the current approach is missing that. So, our research wanted to sort of take that from the ground up and just explore these assumptions. So first we started looking at industrial concentration trends. And what we saw was, contrary to the popular narrative, we actually saw that concentration has actually been declining in the data since 2007. And that got us very curious. Why are we coming out with such a different answer than a lot of people who have come before us, a lot of other literature? And when we started exploring it, what we saw was that most papers exploring concentration had limited attention to industries that maintain a constant definition in the census data. But if you don't do that and you start with all industries, you don't get the same result. Now, maybe you want to, for many cases, look at that restricted sample, but the problem with doing that for characterizing concentration trends is it turns out that that sample has a much lower initial level of concentration than the industries that are getting reclassified. Furthermore, if you then do restrict attention to those industries that have not been reclassified, that everyone's been focusing on, what you see is major mean reversion in the data. The most concentrated industries are becoming less concentrated, and the least concentrated industries are becoming more concentrated. So that tells us that when we see trends in concentration, much of that might be nothing more than transient shocks causing temporary changes in concentration that then dissipate. then also, and this is very consistent what a number of people have found, we then looked at the sort of most recent literature on concentration, and we found that concentration is generally correlated with good things. I don't mean to say that's causal. I'm not saying let's go concentrate the economy. But I am saying in general, the organic process of concentration is associated with higher output, higher employment, and higher wages. As far as innovation, we wanted to try and take a really comprehensive look at just the general relationship between mergers and innovation. And we found this wonderful data from the National Science Foundation, the NSF, that tracks R&D and patent activity by industry over time. And to my knowledge, this data has never been used in the antitrust world to study these issues. So we connected that to the industry-level data from the FTC's HSR filings, and we found a strong relationship between mergers and R&D and mergers and patents. Now, that's not causal in the microeconometric counterfactual sense of the word causality, but we then did look at the direction of causality at least, and we found that the direction does indeed go from mergers to R&D and mergers to patents. So what we sort of draw from this is, well, I guess stepping back a second also, so the merger guidelines are the culmination of this year-and-a-half-long process. And of course, the text of the guidelines themselves matter. But these concerns are very much baked into the guidelines. There is a lot of emphasis on trends in concentration. This is easy to miss, but the guidelines have this very specific language that when looking at innovation, they are reserving the right to look at broader relevant markets than for the rest of the inquiry. And I think sort of most importantly, the language on efficiencies says that an efficiency is non-cognizable if it creates a trend towards concentration or vertical integration. So what are our sort of takeaways from that? Well, first, I understand the case law seems to point to considering trends in concentration. But I think if we are going to pay attention to trends in concentration in merger analysis, we need to be extremely careful because they are generally an unreliable indicator of trends in market power. And they can often be correlated with very good things, with competitive benefits. I think as far as mergers and R&D go, I think it's fine if we want to look at broader market definitions when we think about innovation. But if we do that, we really need to pay attention to both the benefits to innovation at the industry level, rather than just the costs. And then most importantly, if you think about what innovation is, or really any efficiency, it's something that's going to attract consumers, right? So if a merger creates innovation, it is extremely likely to create a trend towards concentration. Because the way that innovation will be perceived is it will create momentum in the market, it will attract consumers, and that will be reflected very possibly, very often, in increased concentration. So it almost seems like the way that the current discussion of efficiencies is phrased, that we are potentially saying that it's non-cognizable to consider efficiencies that create innovation. And I think that's extremely problematic. Okay, I promised a bright side, so let's turn to that. I think the really great thing about the guidelines, and I'm really glad that Aviv mentioned this in his opening here, is this is a really great opportunity to consider new sources of data and new sources of information. And I think the guidelines have done a wonderful job highlighting that potential. We have here, Aviv is the father of merger simulation. One of the biggest innovators in structural econometrics. And those methods have been very useful for adding rigor to antitrust analysis. But they also have limitations. For instance, they have rigid assumptions, and it's hard to capture some of the complexities of competition. So I think that the new guidelines, in many places, they're inviting us to add to our toolkit things other than just sort of these very specific set-piece analyses that become a big part of merger analysis, but to bring in new sources of data. And I think there's a lot out there, like this NSF data I mentioned, and also data like the Business Dynamics Statistics database from the US Census Bureau, which has lots of great information about firm entry and firm growth.
All right, so there's hope for our graduate students that are going to do research in this area and build careers. All right, thank you, Rob. So Aviv, I guess there are two things, and you don't have to talk about both of them if you don't want to, because we're about 15 minutes away from kind of our hard break. But I would like for you to help us understand
with the discussion that's even just been here, how the FTC and the DOJ move forward. How would you like to see that happen, or how do you think that might happen? And then also, with some of the things that Rob was saying, the research that is brought on trends, how does that ever show up in a case? Or is it really going to be specific analyses in the case? That's probably the lesser important question. The more important is, how do we move forward?
Okay. I was afraid you were going to ask me to respond to all these comments, and my response would have been, how many days do I have?
You can submit written rebuttal later.
We will submit it at some point in the next few months, and actually I guess that's my answer. So let me just start with, well, first let me thank everyone. Look, we appreciate this. We really do. And I'm not just sort of saying here, hey, here's my chin, put another one on it. Although, look, I've had worse, much, much worse. We're here to hear. We'd like to hear the good, the bad, and maybe most importantly, the misunderstood. And I think there are a lot of things that we were misunderstood. Now, I don't want to say people misunderstood us, they were not getting it. No, we were not clear enough, right? It's our responsibility as authors to be clear, and we will clarify that. And that's going to take me to the next step. So we're in the process of reviewing the comments. I've started looking at them myself, but not only are there thousands of comments, there's literally tens of thousands of pages. I mean, some of the comments are actually longer than the 51 pages of the guidelines plus the appendix. Quite a few are actually longer. So it's going to take a while to go through, and obviously some of them, it's not just, a bunch of, blah, blah, blah. There are actually some very substantial points that we're going to have to go to. What we're going to do is we're going to evaluate those. We're going to make changes. I am pretty sure that the final guidelines are not going to be identical to the draft. How different they're going to be, I don't know. I mean, that's going to be, it's truly an open process that I think even our leadership doesn't know at this point. It's really, we really are coming to this with an open mind, okay? And then we'll publish the final guidelines, and that will be the answer, okay? And it's going to take me more than a few days, not just me, the team to get there. Let me just sort of touch on a few points. Again, not respond sort of point by point to what was made, but to me, actually listening kind of the back and forth, actually in many ways confirmed some of the points we're making. So for example, think of, we've heard both Carl and Bruce kind of push back a little bit on this, dichotomy between vertical and horizontal. But actually at the end of the day, I actually heard, I think, Bruce agreeing of saying, yeah, there's vertical effects and horizontal effects. They're different. They belong in different guidelines, and they are, right? But this label of any given merger as being only vertical or only horizontal, the economics does not support that. I mean, it does in extreme cases, the ones we take to the textbooks. But guess what? The agencies do not make decisions in the classroom, right? We have to make them in the real world. In the real world, there's complements, there's substitutes, many mergers involve both. And that's what I sort of mean, like, you can't sort of say, hey, we're going to draw the line and say this one only invokes this or this one only invokes that. You have to really look at them at the totality. And yes, they are different effects. No one's claiming otherwise. I think we agree on the economics. So that's kind of, I think, a way to confirm what we're doing. I could respond to a bunch of others. Let me just actually take, something that, Rob sort of touched on, and Mark, you did as well. So we do touch on dynamics a few points. I think, those are relatively, new ideas, new guidelines. As a result, maybe the drafting needs a little bit more work. But the idea of what we're trying to sort of do there is something that really should not be controversial at all, okay? What do I mean by that? When we evaluate an industry, we shouldn't just be taking a snapshot, right? We should be looking kind of within context. And what's the context? The context is what's happened in the past, and the context, maybe even more important, is where are we going in the future, okay? That's kind of the context in which we kind of introduce these dynamics. Now, did the drafting get it right? Probably not, okay? We need to work on that. But I think the basic idea of saying, hey, let's look at dynamics, let's look at sort of the effect, that's there. Similarly, when we talk about merger simulation, right? And I think we've introduced language, and again, this is something that's near and dear to me in my academic research, But we say when we go and take it to policy, we have to realize there's a limitation of what we can do with analytic models. We can't model every single thing in the world, and that's not what we're intending to do, right? We're trying to illustrate some economic effects and kind of put them in a clean world, and that's an important piece of evidence, right? But it's not ultimately saying, look, this is not an exact prediction about the future. It's really trying to sort of quantitatively illustrate the points, and I think that's one of the key points that, we were all pushing very strongly to sort of clarify that, to say it's a piece of evidence. We're trying to make really hard decisions, and we should use every piece of data, every piece of information that we have to teach us about the key question, which is, does this merger lead to a lessening of competition? And there's a lot of different pieces to do that. So that's basically what we're trying to do. Let me stop there, because if I can go on
All right. Well,
for more than this afternoon. But hopefully
Okay.
that answered your questions, Mark.
much appreciated. Thank you. So we have about 10 minutes left, and so I will try to get this question to all four of you, because all four of you talk with businesses and their advisors about their business decisions, including mergers, and how they will engage or have their cases with the antitrust agencies. And I'd just like for you to talk about how do these guidelines, assuming they're adopted largely as they are, how do these guidelines change those conversations? So Carl, I'll start with you, then Bruce, then Rob, and Aviv will give you the last word. Carl?
Well, I think that companies who are considering entering into mergers or acquisitions for the last couple of years have understood that they're facing a more challenging, some would say hostile environment than had been true previously. There has been, I would say, a sustained effort under the Biden administration to deter more mergers, and these guidelines are a continuation of that effort. People should know that in addition to these guidelines, there are proposed major changes in the HSR filing, the Hart-Scott-Rodino filing requirements that all mergers over the threshold are required to meet. And those are also quite a substantial additional requirement if they go into effect. So I think what's happened now, particularly if these guidelines go into effect more or less as drafted, is many mergers will either be dropped because of the perceived risk, or the companies, and we're already seeing this a lot, will say, if we're going to go forward, we need the target company will want a breakup fee, and the acquiring company will very likely want a commitment to proceed through the litigation, because there will be a view in many companies that concerned that the agencies will investigate and try to challenge mergers, that the courts will not agree with the agencies, so the companies will need to litigate. So I think we're going to see some deterrence in the short run, companies pressing that, and in the longer run, whether the courts will adopt these guidelines or embrace them the way they have the previous ones, I think is highly questionable. So the deterrence may be short-lived.
All right, thank you, Carl. Bruce?
Well, I guess when I first started in antitrust, economists did a lot of market definition. We could estimate critical elasticities, and I mean that's really ugly stuff that has gone away. But I think if you look at these, and there's Aviv may say that this was a drafting problem, but it looks like there's a re-emphasis on market definition. I mean, if you're going to re-emphasize concentration, and it's not just guideline one. There's a concentration plus factors for coordinated effects, and there's a number when they talk about potential and nascent competition. You can't have numbers until you actually come with a market definition. And so, I don't know if the modern guys who've been doing sort of effects analysis really know what that is, but it's hard to identify demand curves. Sometimes you can do structural estimation, sometimes you can do other things which allow you to get big cost shifts with stable demand, but That stuff's hard, and I think that if that comes back, I don't see that as a positive. But that might be sort of the one effect if in fact there's a reemphasis on structure.
Okay, Rob.
So AAG Cantor has called the response to the new guidelines hysteria and has emphasized in his view that these guidelines are more evolutionary than revolutionary. And we also have heard Aviv here today telling us, that there's really a huge amount of continuity, and much of, what's being said isn't necessarily the intent of the agencies. On the other hand, I do look at the text of the document, and I think about what leadership has been saying, and that makes me think there really is a potential for very different treatment. There's also been some challenges to mergers, like Amgen Horizon, that have been sort of unprecedented. So if I'm advising a company, I am going to say, I think you need to be ready for a different sort of antitrust inquiry. And part of that inquiry will be dealing with topics that you haven't necessarily thought about before, and bringing new forms of analysis into the whole structure. I think another thing that I would emphasize is this is an opportunity at the moment to, I think, start working on these issues early, because a lot of these inquiries and things are sort of areas where companies can look at data, can get the economic analysis done, while they're contemplating and working on the merger, and start, trying to, respond to these new issues as quickly as possible. But I do think, at the moment, it has to be the case that if you're a company thinking about merging, yes, you have to be ready for a different sort of inquiry.
Okay, Aviv. So I disagree, surprisingly. Let me just make a few points. You mentioned Amgen Horizon. Let me just remind you a point. It was brought under the 2010 guidelines. Okay, so this whole idea that suddenly things are going to sort of change because there's different guidelines. I mean, look, the current leadership, they're very clear about their views and where they would like to take antitrust. One should sort of separate that somewhat from the guidelines, right? I mean, we've been operating under the current administration under the 2010 guidelines for a while, right? So it's, so you could have a criticism what the current leadership has done, and you obviously, you can have your views on particular cases and on their views. But if we're talking about the guidelines, you should, let's separate that, right? I gave the analogy of let's separate between how we build a car and how it's being driven. Okay, so your complaints are about the driver, make the complaints about the driver, not about the car. Okay, that's one. Issue of structure, look, Bruce, I think you're actually mischaracterizing both how structure is currently being used. I don't know what world you live in where you think structure has gone away and market definition has gone away. Definitely not any courtroom or any litigated case that I've been involved with. That's one. And second, I think you're unfair to the guidelines by saying these are the very first guidelines that have opened a very clear pathway, if the agencies decide to go that way, to litigate a case without a structural presumption, just based on guideline 2. You could say you could do that under 2010, although 2010 didn't specifically say it. These are the first guidelines to say that. So I think just in pure of being, fairness, I think you should have been at least mentioned that as a possibility. But let me sort of step back. I think the real question, and that's one that Carl touched on, and here I think actually Carl and I are in full agreement. The real question is not about, this guideline or that guideline, what this says or what that says. The real question is what's going to happen to the so-called guideline project. Okay, the project that started in 1968, right, that has given us the merger guidelines, which have been very sort of very helpful. And I think there's, again, we can disagree on details. I think there's actually wide agreement in the community that that project has been very helpful. Okay. Now, I realize that there's many, maybe everyone on this panel besides myself, that are unhappy with the current draft, and it's a draft. We're not going to get there. We're going to change some things. Hopefully, we'll satisfy some of the concerns, but I'm not sure we can satisfy all of them. Okay. Once the final version is draft, and as I said, I hope it will respond to many of the comments we got. I hope that the folks would kind of look at the forest more than the trees, right? Because how these are perceived, both within the community, but also with the courts, it's not just up to the agencies. It's also up to the community, right? And we have to realize that as written kind of for a group, there's probably not a single person, including a leadership, that's happy with every single thing that's in the guidelines, right? But the question is, you have to step back and say, as a whole, what do we think of it, right? So you might not like the case references, and you might say, well, if I were the AAG or if I were the chair of the FTC, okay, I would have done things differently. But that's not the relevant question, right? The relevant question is, can you look behind that, right? So for example, and I don't know where we'll end up on this, but suppose, there's no change on that and people are unhappy with it. Can we step back and send the message of, okay, the legal brief of that part, Your Honor, you should ignore that. You should really go to the legal brief. But there's some good economics here, whether that's in the main text or in the appendix, that should be paid attention to. If that's the message that we send, even if we disagree on exactly, the details, say that's what should be focused, the project will survive, right? And that's what's important. I think we have a responsibility as a community, right? Let me kind of say, people say it takes two to tango. Well, let me use my kind of Israeli background and say, well, it takes a circle to dance the hora. Or as, think of Jewish weddings, Hava Nagila, okay? It takes a whole circle. Come and be part of that circle. Part and help us look at the forest, not at the trees. That's what ultimately, I think, is the bigger question. And hopefully, we can get you to join part of that circle.
All right. Well, Carl, Rob, Aviv, and Bruce, thank you for your contributions today. I specifically appreciate the depth and the character and the quality of your comments. The difficult issues, as I often tell my staff back at the research center, if what we're doing isn't controversial, we're probably not trying hard enough. So good for you for the work that you've done. So now we're going to turn things over to Jeff and the panel of the attorneys. Thank you all very much.
Those who may have missed the beginning of the conference, my name is Jeff Eisenach. I'm a visiting scholar here at the American Enterprise Institute, and we're here to convene part 2 of our symposium on the draft merger guidelines. We're going to approach this panel in 2 parts. First, by talking about the immediate future of the new guidelines, and some of those questions were kind of referenced in the last panel of economists. To what extent will the agencies consider, and to what extent maybe should they consider, the reaction in the antitrust bar and broader antitrust community, in thinking about possible revisions between now and whenever a final version is released. And then the second general theme, what are the longer run consequences as the new guidelines go into place, both as they're currently written and as they may be revised. We have a very distinguished panel of attorneys to discuss this. I am not an attorney, I'm an economist, but they let me teach law at George Mason sometimes, and so I get to moderate a panel of lawyers, which is a great honor. I've learned in my experience in doing antitrust stuff that it is antitrust attorneys are amazingly good economists, and hopefully the feeling is mutual. But but anyway, let me get the introductions out of the way, and then we'll start our discussion. We have 4 panelists today, starting with Tim Muris, and we're going to go down the row, and then we're going to go back up. So Tim will lead off, and then bad cleanup when we're all done. Tim Muris is the George Mason University Foundation Professor of Law at Antonin Scalia Law School. He chaired the Federal Trade Commission from 2000 through 2004. He served as both director of the Bureau of Competition and director of the Bureau of Consumer Protection at the Federal Trade Commission during the 1980s under the Miller regime. Served as a member of the Reagan Bush transition team on the Federal Trade Commission in 1980, which is when I first met him. And prior to that, served at the Bureau of Competition and the Office of Policy Planning at the FTC during the 70s. He is a visiting scholar at AEI and also a practicing attorney. Charlotte Slayman is Vice President and Director of Competition Policy at Public Knowledge, and was at the Federal Trade Commission from 2014 to 2017 in the Anti-Competitive Practices Division of the Bureau of Competition at the FTC. She also served for several years on the Senate Judiciary Committee as a staffer, senior staffer, working with, among others, Senator Al Franken. Noah Phillips is co-chair of the antitrust practice at Kravis, Swain, and Moore. He served as a commissioner at the Federal Trade Commission from 2018 to 2022. Prior to that, he served as a staffer on the Senate Judiciary Committee working on antitrust issues from 2011 through 2018. Last but far from least, Bill Baer is a visiting fellow at the Brookings Institution. He served as Assistant Attorney General for Antitrust from 2013 to 2016. He also served as Director of the Bureau of Competition from 1995 through 1999 at the Federal Trade Commission. Has anybody else done that? I'm not sure anyone else has done that. I couldn't name somebody. Anyway, when he wasn't doing those things, he chaired the antitrust practice at Arnold and Porter, which is not a small thing. We have a very distinguished panel who've been involved in these issues for many years. So let me lead off coming back to the first question. And again, this was discussed a little bit in the first panel. How do you think the draft guidelines have been received? How would you characterize the reaction among antitrust practitioners and academics? Carl Shapiro talked about this some. As Aviv seemed to indicate, there are maybe have been some identified opportunities for improvement. And how, if at all, do you think the agencies are likely to respond or should respond? And we'll start with Tim.
Well,
Thank you, Jeff. It's a pleasure to be here at AEI in this non-sanctioned gathering of the Casto Gear FTC Alumni Association, to which all five of us belong. We won't tell Chair Khan, but I guess since Jen Howard is gone, it's probably okay. With my various affiliations, I should note that I speak only for myself and not the state of Virginia, for which I teach, or the clients at Sidley Austin, of which I'm a senior counsel. I'll just have one comment on Aviv. You need to read comments that Aviv signed on the draft request for comments that were made in January 18 months ago or so. Those comments are very similar to what Aviv had to say today, except every time a sentence says, I believe X, you need to put a not in front of, or a do not, and then the comments would correspond exactly. You could have a long debate between those comments, between that Aviv and today's Aviv. Look, Greg Worden, I think, who was involved, who's a quite interesting curmudgeon who was in the division for forever, recently retired, worked on the 5 previous guidelines, said, and I quote, that these new proposals are a legal brief arguing that the agencies have enormous discretion and that the merging firms have an insuperable burden with any defenses. President Biden, there's a self-proclaimed revolution going on here with Chair Khan and Tim Wu at his side, and Jonathan Cantor would have been there, but he hadn't been confirmed. President Biden proclaimed that the previous 40 years in which Bill and I had a lot to do with were an experiment failed. And that they were going to launch a revolution. Now, there's obviously nothing wrong with that. The FTC, this is the 3rd time in 50 years that someone has come into the FTC to launch a revolution. Jeff and I were part of that in the Reagan administration. But these guidelines are an attempt at revolution, but they claim, mostly with cases, we've heard this today and other times, mostly with cases from long ago, that the law supports this approach. Now that claim is false, but that requires a little discussion of history. I go into this at great length in a paper that is on AEI.org. It's a long paper. The merger part is a part of it. The official version is published in June. The working paper was published in January. It's called Neo-Brandisian Antitrust, Repeating History's Mistakes. But Chair Khan said almost a year to the day from today, last year, she called for, quote, fidelity to the law. And she said her predecessors, she criticized her predecessors, that's us, Bill and myself, among others, for, quote, sidestepping controlling precedent, close quote. Now, what does that mean? What were those controlling precedents? Those controlling precedents, if you look at all of them, okay, and they did not have the courage of their convictions in this draft, but those precedents are precedents that caused the people who were appearing before the courts to not dare claim that they were cutting prices, because if they cut prices, they were going to raise their market share. If they raised their market share, they were going to harm their competitors. And if they're going to harm their competitors, that was a good reason for the courts to find there was a problem with the merger. In the 60s and through the early 70s, the government almost always won. And the courts, if they had to, would invent markets that existed, as Justice Harlan famously said in one of the Supreme Court opinions, only on the pages of that opinion. In that world of these so-called controlling precedents, the business development, business improvements were used, as in the famous Vaughn's grocery case, to condemn the mergers. Now, the first guidelines that were issued in 1968, held that even in unconcentrated markets, if one firm had 5% and another firm had 5%, and it didn't matter what the other firms had, that 10% was enough to condemn the merger. Well, that, believe it or not, was temerity, because the Supreme Court had thrice, we could make a biblical reference here, had thrice held that you don't need 10%. Single digits was enough to condemn a merger in an unconcentrated market, including in that off-cited brown shoe case. So when Chair Kahn discusses controlling precedent, if she really meant it, those would be the cases to what she would return. But of course, those cases are no longer controlling. The law began to change, and it began to change, and it has changed, but it began to change decades ago. In 1974, that's a long time ago. That's when I started working at the FTC, and I'm old. That's a long, long time ago. The Supreme Court said that concentration itself was not enough. Yet these guides, Aviv notwithstanding, as Carl and Herb Hovenkamp and others who regard themselves center-left have said, these guides abandon market power and consumers to focus on concentration. Now, a conclusive, I think, evidence of the fact that the law changed and changed long ago was what happened to the Federal Trade Commission in court on mergers in cases that it filed in really the Carter years. We're talking about a long time before a lot of you, probably most of, not on the panel, but a lot of you in the audience were born, okay? The FTC, like the rest of the government, was winning almost all of its cases, okay? But if you look at the cases that were decided in the late 70s, beginning of the 80s, these were all cases filed in the second half of the 1970s, the FTC's record was 8 wins and 14 losses in merger cases. Now that's better than Biden, okay? But that's still terrible. And they were using these so-called controlling precedents, okay? The courts rejected that law of the 60s a long, long, long time ago. So don't tell me or anyone else that these citations to old law represent the merger law of the 21st century, let alone the merger law of the 1980s.
Charlotte, I guess you disagree.
Yes, but I'm going to endeavor to answer the question that was asked, which is about how the guidelines have been received. So I took a look at some of the 3,000 comments that have come in. I think it's incredible that there are 3,000 people are interested in merger guidelines. That seems like big progress. And there were actually a lot of comments from regular people, not organizations like mine that are submitting 10-page comments, but just a paragraph or two about someone's personal experience. It was workers, it was consumers. People are really excited to learn about antitrust, which I think is happening as a result of this movement to show people how antitrust is affecting their daily lives. And that is happening. And those people are excited about the new guidelines and writing in and making up those 3,000 comments. Aviv talked about the overview at the beginning, right? Which I think part of the purpose of that is to simplify these concepts for people who are not antitrust lawyers. And I think that is working. People are interested, and it's lowering the barrier to entry for this important policy discussion, which I think is really important and something that I've been trying to do. But the organizational comments, absolutely, there are many critical comments along the lines that Tim was describing. There are also many organizational comments that are supportive. What folks might be interested to hear is that there are also comments asking for the guidelines to go farther. I noticed some of those, asking to fully eliminate any efficiencies defense, to lower the market share thresholds for the structural presumptions, to add diversity data to the type of data that is collected in merger reviews, and to consider a decrease in workplace diversity to be a lower, a diminishment of quality of that workplace. So there are a lot of creative ideas. I also saw some ideas for different structures of the guidelines, that there could be separate documents for describing the agency's priorities and how the agency interprets the law, how the agency is applying economics. So I think it's like a really great process for the FTC to have to receive all of these comments. One of the things that folks have talked about is elevating the economics section of the guidelines to be sort of receive its due. It's a very important component of the guidelines. It's currently marked as an appendix. So I think that we might see that one be increased. I also wanted to harken back to something that came up in the last panel about the importance of this project of guidelines. We really want the courts to find these guidelines to be useful, and I think that should be the priority of the agencies in terms of considering the types of changes to make. I want them to stick to their guns on the importance of the policies that we're working on. But the priority also needs to be to make sure that these are compelling to courts. So I think that we might see additional cases cited. I think that we might see an additional commentary to give some more examples of how this is going to have a real-world impact. I think taking some of that feedback, and we're hearing, of course, this posture of being open to feedback, I think that that can be helpful in terms of making sure that the courts are going to use these guidelines going forward.
So first of all, thank you so much, Jeff, for hosting this, to AEI for having us here. It's great to sort of be back at AEI and to engage in this very important discussion about guidelines that may have a real big impact. One of the things that strikes me about the conversation that I heard, at least for the part of the economist panel that I was privileged to listen to, our discussion already, and in particular, some comments that Charlotte made, and also just watching the broader public discussion, is I feel like sometimes we're having a series of different conversations about these guidelines at the same time. Because the discussion about the guidelines, to some extent, is a discussion about what is the goal, right? Are we engaged in a revolution? And we definitely hear some paradigm shift type language, a rejection of the mistake of the last 40 years Tim referred to in the president's remarks back in July of 2021. And then we hear, in particular now, leadership of the agencies talking about continuity and evolution, on how this is static. Those are two very different views about what's going on in the guidelines. And they are largely not, they're not tenable together, right? There is a direct tension between those two claims. Now, there can be some continuity together with revolution, but there's definitely been a lot of branding around this. And I think it's important in understanding how the guidelines are received to understand how they have been marketed in advance. That's an important part of it. So one thing a word I just used was marketing. Charlotte was referring to how sort of ordinary people, as you called it, are interacting with the guidelines. That's a thing in the world. But another thing in the world is guidelines as guidance for businesses, right? I'm a lawyer, and one of the things I do is I counsel clients on how are the agencies likely to receive the facts here under prevailing law. And the merger guidelines, I think the project of the guidelines, the historical project, wasn't intended just as a document to interact with ordinary people. They're also intended to be guidance. And I think evaluating how important we think that is as a goal, and you may not view that as important as a goal, but if you think it is, that ought to be something that bakes into your calculation of how to proceed. I think other factors that the agencies might be thinking about is stickiness. Are these guidelines going to stand, I'll leave aside the courts for now, with a new administration that might come? Whether you love them or whether you hate them, the 2010 horizontal merger guidelines were kept in place by the subsequent administration. And one of the things that that meant as a practical matter is that the businesses that had been planning based upon those guidelines and the lawyers that had been advising clients, on those plans that the businesses might make would be able to give guidance, and that guidance would sort of last. It would stick. The more we introduce variation, and maybe you think the variation is warranted, maybe you don't, but the more we introduce variation, we also invite future variation. And so what we may see are bigger swings in policy over time. And one thing the agencies may want to consider is the degree to which they want to invite that swing. Does that serve, right? Does it further the goals that they wish to achieve? Does it undermine them? What is its impact on consumers, also on businesses, that sort of thing. And then finally, the issue we've all sort of been dancing around, and I think we'll talk to in the context of the next question, how are courts going to receive these guidelines? And I'll save some of my thoughts on that. I think that we heard already a lot of debate about what role economics is playing. I think we've seen a debate, Tim was alluding to it, about to what extent the guidelines are in fact faithful to the case law, both the historical case law from the Supreme Court, but also a lot of modern merger case law, which admittedly didn't get to the Supreme Court, but nonetheless continues to guide courts in their evaluation of mergers on a day in and day out basis. And also the cases cited, right? Are the citations faithful to what we're doing? So I think critical to all of this is a very important discussion that needs to be had, antecedent to the outcome and antecedent to the changes that might be made about what is the point of the guidelines. Because I think on some level, unless we get agreement on what those points are, where they are in tension, we're going to have trouble resolving that tension in terms of arriving at a final outcome and then having that final outcome have the impact that people want.
Bill.
A lot said. I'll try not to repeat or disagree too much with what's been said up here. Look, an opening point is, this goes, Jeff, to what you said in your introduction. This is a healthy process. This document got out there after lots of internal work. Unlike some of the guidance the agencies have developed, this was vetted with career staff. They were heavily involved in it. Once a draft was ready, I'm told in May or so, they did another 2 months of talking to the staff, lawyers, and economists to make sure there was buy-in that are reflected, not just the leadership, but the career staff view on it. That's very healthy. They had a 60-day comment period, and obviously they got a hell of a lot of comments. That's a good thing. These are drafts. They're doing a few workshops afterwards to further stimulate the debate and inform what's going on. Aviv has said they already know there are some changes they're going to make to try to deal with their criticisms. That makes this a healthy process. So remember, it's a draft. Remember that both agencies suggested they're going to take the comments seriously. Also remember that this administration does embrace a concern that the courts have basically changed Section 7 of the Clayton Act to make it much more cautious, to put a much higher burden on the government to prove that there's a risk to concentration, or rather risk of market power from a particular merger. The burden, I've seen it in court, is quite high, and that tend to substantially lessen competition. The burden on the government is much more prove that there will be a substantial effect on competition. So I think trying to move the courts back in a direction where they are demanding a little less of the government and trying to protect against mergers that pose a serious risk, not prove a certainty, is part of what these guidelines are trying to do. And in my view, it's what they should be doing. Tim talked about relying on decades-old Supreme Court decision. Well, guess what? Dave Lawrence, who's head of policy planning at Justice Department, did a little research gave a little talk about this a month or so ago. You know, brown shoe is a decision that is criticized for some of the analysis in there, and it's not cited for that analysis either in these draft guidelines or by briefs DOJ and FTC have submitted in recent years. But it is cited as good law in 50 of the merger decisions that have been issued by the federal courts in the last 10 years. So the notion that it's outdated, it has no presidential value is, I think, erroneous, to put it mildly. But the other couple of quick points I want to make is what these guidelines do in their basic statement and in guideline 1 is say, look, any transaction, we need to examine what the competitive dynamic is between the merging parties. And we need to assess what may happen, what may tend to happen if that is eliminated. Is that posing a risk to competition that had existed, whether it's horizontal, vertical, or diagonal? I do think putting these things all in one document and not forcing a front-end label is actually a good point of Eve makes. It's a better way of looking holistically at a transaction and trying to figure out what its potential competitive effects they're going to be. I do think that some of the criticism here, whether well-intentioned or not, is coming from people who never met a merger they didn't embrace. Some of the antitrust community, their job is to be out there advocating for mergers. They didn't like the old guidelines. They disputed whether the old guidelines applied to mergers that, in my view, never should have made it out of the corporate boardroom. They were that obviously flawed. And so some of that noise, I think, is not deserving of much credibility. On the other hand, there are a whole bunch of serious and respected lawyers and economists who do have questions about what the purpose and effect of some of these revisions are. I've read many of those comments, and those are thoughtful contributions to the debate. And I think the agencies are well advised, and I think they know this, to take those into account. One final point, I always saw these guidelines as, these drafts and other guidelines, as dual purpose. One is to inform the courts, that's been discussed, but more to tell the public and the business community, as you said, what's our screen? What are we going to look at? And the fact that we say we're going to look at various aspects of various transactions, whether vertical or horizontal, does not mean we are going to challenge them. The latest enforcement stats, despite the uproar about crazy antitrust enforcement at both agencies, roughly the same percentage under this administration of deals getting second requests as in the Trump administration. Roughly the same percentage of challenges of the percentage of overall filings. So there is a little bit, somebody used the term hysteria, there's a little bit of an overreaction to how much change has happened and is in the offing. These are smart leaders at both agencies. They know they're going to be held to account in the courts. They can't unilaterally rewrite the antitrust laws. But at the same time, they are right to suggest that some of the more recent judicial interpretations, recent meaning the last 2 or 3 decades, Tim and I roughly are the same vintage on this stuff, that they've been too cautious. They've imposed too high a burden on the government, and trying to move the courts or educate the courts as to what they are missing is an important part of what these draft guidelines are, in my view, intended to do.
Two points. Brown shoe. These guidelines, one of Baxter's great innovations was changing market definition, and it flowed from as Herb Hovenkamp talks about in his longer piece, recent one that he's put out. it flows from Stigler's oligopoly and the whole theory of the 82 guidelines, the whole hypothetical monopolist. And it was meant, and Greg Worden's excellent piece discusses this, it was meant to do away with the standardless brown shoe test. Now, these guidelines say, well, we got both. We'll pick and choose. It is a problem. It's a problem of the agencies giving themselves more discretion. That's the first point. Second point, as Carl said, there is a fundamental difference between a merger between competitors and a merger between complements. And the people running the agencies, especially at the FTC, you have one commissioner who believes vertical mergers are worse. And she says it. And that is misguided. And these guidelines are contributing to that fundamental error.
Any other, Noah?
I wanted to touch on one point that Bill made, where you, I think, correctly noted that the merger enforcement statistics haven't meaningfully moved. Let's leave aside the sort of litigation outcomes, and in some respects, the enforcement numbers are actually down. One of the issues, I think, with at least the draft guidelines that I think the agencies will need to grapple with is if you announce that the number of mergers that are illegal dramatically has expanded, you say, whether you couch it as that's just something we will look at, or suggest that it's something you will challenge, or there is a presumption against this, and there's a lot of light presumption in the guidelines, you're suggesting that you believe a lot more mergers are in fact illegal. If you fail to follow that up with enforcement, it leaves people unsure, right? And I think deprives on some level the people who are trying to decide, do I do this thing? We're trying to figure out, is this actually illegal under the law, which I think we have to believe is something that exists out in the world. The bigger the dichotomy between the announced intentions and the sort of enforcement agenda, the less useful I think the document becomes as a matter of guidance. And you'll forgive me, I'm going to keep harping on this. This is, of course, a preoccupation of those of us who are in the business of advising people how to act, which on some level, again, I think is what guidelines are intended to do.
So I think the reason for that is that the resources that the agencies have has not also increased, right? And so they're still able to only, bring the same number of cases. What I hope is that they are taking seriously what I believe is always the responsibility of the agencies, which is to be strategic about the cases that they're bringing, and bring those hard cases that are going to give us better law over time. That's a long project, right? It doesn't necessarily show dividends right away, but I think that could lead to the statistics being the same. Well, actually, I feel like we are making progress towards improving the law and clarifying the law.
Yeah, I mean, the agencies have gotten tens of millions of additional funding in the last few years. I mean, it's like a 30% budget increase, so it ain't nothing.
But it needs to be a lot more than that.
Well, but there is more money, right? That's a thing that happened in the world. Yeah.
Bill Baer went through the merger wave with 1,000 people and did an excellent job. So, I mean, there's what he did.
You can't argue with that.
Well, in looking back, to the late great Bob Potofsky, there were deals we wanted to challenge that we really thought there was a risk of anti-competitive harm, but we thought the case law was such that we were likely to lose if we didn't bring them. And I think, in retrospect, I would have brought more of those cases at the FTC in the 90s and at DOJ from 2013 to 2017. We did push the envelope a bit, and with some success. So I'm not one of those that says you need to bring losing cases in order to get Congress to change the law, but I do think there is a legitimate concern that over the last 40 years there's been underenforcement caused by an overly restrictive view of Section 7 of the Clayton Act by the courts.
I'm not going to become a panelist here, but something Bill said forces me to make a brief comment, which is
You're entitled.
You mentioned the people who had never seen a merger they didn't like. And until about 2000, early 2000s, that would have applied to me. Then I went to work for Harry and Simon, where I ran their economic consulting operation. Harry at that time was the largest economic consulting firm, the largest antitrust firm in the world, and we even had its own in-house economic consulting operation. And so I was in a position at that point where firms would bring their proposed mergers to their antitrust counsel, including its in-house economic consultants. And I saw a whole bunch of mergers I didn't like, and realized that the role of the antitrust bar, our role at Harry, was to tell a whole lot of people who thought this was a good idea that there was just not the first chance in hell that their merger was going to get approved. So there's a big screening process that goes on there. And on a more serious note, which may explain something about the statistics, right? So I think part of the intent of the enforcers, I think Carl may have said this, is to deter. And so in that sense, they're seeing a selection bias issue where transactions that would have come to the agencies are not getting there in the first place. All right, let's move to the second part of this discussion. We've got about 15 minutes left. I read Tim's speech recently, and I thought the point that he made, this is in commenting on the 82 guidelines, was that their power really had been on their impact on the antitrust jurisprudence, the way people thought about the application of economics, the application of legal principles to the merger problem, to assessing mergers. And so with that in mind, and we're going to have a different order here. Charlotte, you're going to go first, Noah second, Bill, and then Tim. Rob referred to the fact that we're living in there is a political context here, and I say that with a small p. There clearly is, on both sides, I think, of the ideological and partisan divides, a populist sense that goes against bigness, that kind of would be sympathetic to the phrase big is bad. These guidelines are part of that milieu happening in that space. So to the extent you want to take that into consideration in thinking about the answer to the question, how will these guidelines over time affect the way we think about antitrust jurisprudence, the body of ideas that underlies it, and how will that play out ultimately in the way we think about mergers in the economy over the next decade or medium to long term? Charlotte?
Yeah, so one of the things I think about is just the value of this document to practitioners and to new practitioners and to advocates like myself who are trying to participate in the discussion. Even as changes may happen in the next draft, I think the fact that this draft is so heavily cited is really educational for folks, and I think that's really useful. So antitrust law was written broadly, and I think is intended to change over time as we learn more about the economics. And that has happened in ways that I'm not very happy with, but it can also happen in a direction that I think will be much more useful. And I think that's what these guidelines are doing here, is updating the economics, using the standing precedents that we have, but sharing this updated economics. There are so much more understanding of economics, particularly I think of platforms, which is where a lot of my work is, that we have been needing and missing. And I'm so glad that that is now reflected in these guidelines, and I'm hopeful that courts will see that and take advantage of that. And I think that it is, Noah, you were talking about, is it a revolution or is it consistent with the past? And I think it's really, in the middle, right? A little bit of both. And that's the responsibility of the agencies, to be guiding the law to slowly improve over time. And you're not able to do that whole revolutionary project with guidelines. We're going to need Congress to really do that. We're going to need new legislation. And that's something that we're working on often, to try to improve antitrust law in Congress through the statute. But there is a lot that agencies can do and I think are charged to do. And part of that is through bringing cases to build new case law, and part of it is through guidelines to bring that new updated economics. So one of the examples I think about is the Joe Simons put on these series of workshops about antitrust in the 21st century, and one of the big things that I think was like quite a popular talking point there was about type 1 versus type 2 error, and erring on the side of blocking more mergers or erring on the side of letting more mergers go through. I think for many years we had this sort of economic assumption that if you let a merger go through and it turns out it was anti-competitive, well, a lot of new entry will happen and compete away those monopoly rents, and it'll go back to equilibrium, we'll be okay. And so we should err on the side of letting more mergers go through rather than blocking more mergers. I think that's been very clearly shown not to be the case. And so one of the updates that I was sort of looking for was we're going to shift that, and we're going to now err on the side of blocking more mergers, because we recognize that in reality, new entrants don't come in and compete that away. And it's actually much more difficult to replace that lost competition than we thought. What I actually see in these guidelines is what I think is a much smarter way to do it. I'm so glad that we had Aviv Nevo and Susan Athey writing these guidelines, because they're brilliant economists. But recognizing that this is not a prediction of the future, this is actually just looking at the incentives and structures and identifying if there is a real risk of harm to competition. So this is not a fight between the experts about which future is going to happen, which is obviously an impossible task. But making that risk assessment, I think that's really valuable. Taking vertical mergers more seriously, I think that can be a lasting impact of these guidelines. Something I was really disappointed about the 2020 guidelines was this very clear positioning of vertical mergers as generally pro-competitive and not a concern. I'm really glad that that is fixed in these guidelines. And the platform economics, as I said. So of course, they're not regulations. And so as we've talked about, courts will need to decide how much to follow them. And so that's the big question that hopefully we'll see in future drafts, get a better sense of what that will be like. But a lot of it, I think, depends on us and the reception that they receive at the next stage.
Noah?
Okay, sort of a few thoughts. And actually, let me start with vertical mergers. I sort of lived through the rise and fall of the vertical merger guidelines. Blessed be their memory. Those guidelines existed at a time when I think the agencies were bringing novel vertical cases. It is just not true to say that vertical mergers weren't receiving attention until these new draft guidelines. I don't think that's a fair characterization of the agencies. Aviv talked earlier about how, he was referring to one case in particular, but these cases were brought under the old guidelines. I'm not sure that was quite an accurate representation, but I think it's very fair to say that the vertical merger guidelines were consistent with some very aggressive, some edge cases, some of which I voted for, including cases brought by Lena. I voted for 2 vertical merger cases with Lena, and I thought those were perfectly consistent with the old guidelines. I think the fact that the old guidelines recognized efficiencies and recognized that EDM adhered in vertical mergers was something that set off dissents, but it's not clear to me that the economics on that have been consistently disproven. So I do think it's important to recognize where practice and where guidelines are in fact breaking from the past. I agree completely that we ought to see new economic learning, including about platforms, reflected in the guidelines. I think one of the criticisms we heard earlier is that some of the case law are citations, or some of the citations go to case law that reflect in economics, structure, conduct, performance, Joe Bain in the 1960s, where they're relying on that. I don't think it's fair to describe that as sort of modern economics. The defense seems to be, and I think this is a debate that people are having, and perhaps a fair debate, is do we just need more enforcement and more deterrence because we think we've seen on a broader level concentration in the economy and that's creating problems? That's obviously a robust debate that we're not going to settle here, but a lot of the defense, it seems to me, at least that I've read, has been, well, whatever the specifics, the point is where we're going, and that's what a lot of people like. But I want to kind of step back think about two things. One is courts, and the other is the market for corporate control. Like when it ultimately comes down to it, are we going to see more M&A? In terms of the courts, Howard, I don't know whether, excuse me, Howard, he wrote it with Howard Shalansky. Carl Shapiro was on earlier, and I don't know if he referred to it, but he and Howard Shalansky have this article that studies why the 2010 merger guidelines were successful in the courts. Like, why did courts adopt them? And one of the things that you see in the article is that people weren't fighting over the guidelines. Like, they would go into court, both the parties and the government, and they would say, well, we both agree on this framework, and then let's fight about this case within the context of this framework. And even though the courts always recite, look, the guidelines aren't law, they would then say, but the parties agree, and so we're going to apply this framework in the context of the litigation. We don't know what will happen. And it's possible that because the agencies have said something, the courts will defer to their interpretation of law. But I'd venture a guess that if the parties start litigating the guidelines, like they don't agree and they go into court and they fight about that, you're going to see what may be a different reception. Now, to be clear, a good litigant will also say, yeah, we went under those too, right? But to the extent the guidelines themselves become an issue in litigation, we're going to see, a different process of scrutiny by courts, and we'll have to see how it plays out. Like, I don't think it's a settled question. But to me, the real question comes down to something that Bill and that Jeff were talking about, the question of deterrence. Both the leaders at each of the agencies have talked a lot about the broader project here being to deter anti-competitive mergers. And I think it's fair to say, looking at the draft guidelines, there is a view that a lot of mergers are anti-competitive. I found myself in a conversation a few months ago with a group of investment bankers, and they were like, is it working? And I'm like, is what working? And they're like, are the mergers being deterred? And I think this, on some level, is going to be the thing that we'll all need to watch. And it's going to be hard to measure, right? You're not going to see the person who says, well, I would have done it before, but now I'm not going to. And maybe, it's above 30% in terms of market concentration, or some easily or relatively easily identifiable threshold crossing that you might find. But ultimately, the project here, as announced, is one of deterrence. And my own personal view is the things that tend to drive merger waves are a lot more than regulation, right? It has to do with the cost of capital. It has to do with, I can use my equity, which is worth a lot to buy you, or debt is cheap, or debt right now is not cheap at all. And so that's a deterrent. And that, I think, on some level, being the goal of part of this project, I suppose will be left to the other panel, the economists of the world, to judge whether it succeeded in that regard.
Bill.
Thanks. Going back, I think, to something Noah said in your prior comments about these draft guidelines being perceived as a radical departure from the prior guidelines, from the case law. I don't think they are, and I think it would be a huge mistake if the agencies sold these as a Gestalt switch. Okay, guess here's the framework you had before, now here's your new framework, let's go to work on it, right? I don't think that's what these things are trying to do. I do appreciate that in focusing so much on concentration and presumptions that flow from demonstrating a certain level of concentration in a market that will be increased significantly by a particular transaction. The guidelines did not talk enough about that being a rebuttable presumption, that merging parties still can come in and show the benefits that dwarf, undermine the presumption, fully rebut the presumption, and indeed, there are other benefits that make this transaction, even if you see some risk of competitive harm. That's still solid case law. It's embraced, not quite as, maybe not quite as much as it should be in these new guidelines, but it doesn't change that basic structure of, yes, you can come in and show a certain concentration level resulting from the transaction, and you may be entitled to a presumption of illegality, fully rebuttable, with the government then having the chance to come back in and offer up additional evidence about competitive harm. So I think this maintains the analytical structure. It was used in the Section 2 case, Microsoft. It was used in the Baker Hughes case. That structure is maintained and embraced by these guidelines. It's a question of what evidence is relevant. Is it only the modeling that Aviv talked about that has limits to what it could do? You can't necessarily model everything to a degree. These merger challenges need to be about facts in addition to the economic modeling that goes on. And I think the guidelines are trying to reinforce for the courts that there's more to it than having a couple of brilliant experts up there totally disagreeing with everybody on everything. So we'll see how this all plays out. But I do think, as I said a couple of minutes ago, this is a healthy debate, and it will be an opportunity for the two agencies to incorporate some of the comments that have made and make more explicit the degree to which this is not a Gestalt switch. It's not a dramatic change in the analytical framework. It's an effort to improve it.
Tim, you're going to get the final word here, and we'll go a couple minutes over. We'll give you more than 2 minutes.
Well, let me talk about one thing that's unequivocally a giant change in these guidelines, and that's the movement from Obama's 2,500 back to Reagan's 1,800. And Bill Baxter, I had the honor to talk to him a lot about this. When he issued the 82 guidelines, he picked 1,800 in part for structural reasons. And what that means is 1,800 is the level at which you have 6 equal firms would merge to 5. 2,500 is all the way down to 4 to 3. Because of the magic of squaring, 5 to 4 is 2,000, which is a lot closer to 1,800 than 2,500. And those of you who are arithmetically challenged can do the calculus to figure out why it works that way. Now, the key is there is an empirical basis for the 2,500. And that empirical basis was something I started as chair, and it was continued by John Leibowitz through Deb Majoris. And that was to go back to when Bill and Bob Petoskey was there, to look at all the second requests for a long time period. We're talking over 15 years. To look at the second request memos of the lawyers and the economists and write down what did the memos have to say about the concentration, the number of significant competitors, the ease of entry. What did the competitors have to say? What was there about efficiencies? Was it a unilateral case? Was it a coordinated case? And they put all this together, and it turned out that 4 to 3 was over this long time period, and it was consistent. Even from the merger wave to very early Obama, was the marginal case. And by marginal, that meant that it was close to as likely to challenge as not. And challenge, usually meant a consent. And now that meant, of course, that didn't mean that 5 to 4s were never challenged. There were a lot of them challenged, or that 3 to 2s were always challenged. There were some 3 to 2s that were let go, although frankly, there were a lot more 5 to 4s challenged than 3 to 2s let go. Bill was involved in, I guess, the most famous 3 to 2 that was approved, right? The Boeing, weren't you involved in Boeing, McDonnell Douglas, yeah. Mm-hmm. But there were very few 3 to 2s, but there were a few. And there were not many 6 to 5s challenged. And if you strip out energy, there were very few, but there were some 6 to 5s. But the point is that the movement, that is a very big move from what the merger data showed. and the merger data is the population, okay? It's everyone for a long time series. Now, it's possible that in almost all of Obama and in Trump, that the courts or somebody let up and that the standards changed. There are people who claim that we need to move, and they argue to move. We ought to move because there have been some bad court decisions. Well, the truth is, whether you think they're bad court decisions or not, the government has overwhelmingly won until the Biden administration, most of the cases. John Quokka has done these merger retrospectives, or he's done database in these merger retrospectives. There are a lot of people who have said his selection criteria, I agree with this, I've publicly talked about this myself, render his data quite unreliable. The new NBER study, I think, does quite a number on Quokka. That's this study of retail mergers, which itself is provocative. It can be read to indicate that it can be read both ways. It says there have been efficient mergers at high levels and mergers that should have been challenged that weren't challenged. There are two problems in trying to generalize some of that studies. One, it was only retail mergers, and in the FTC's retrospectives, retail happened to be an area where the FTC challenged a lot of 5-4s. And the other thing was there's no confidence that study, it's not the fault of the authors, that the data that was using was measuring antitrust markets appropriately. But the point here is there is a great, and Bruce mentioned this, there is a great experiment to be done that FTC somebody can go back and they can take some randomly selected sample. They can buy the data. The best way to do it, Bruce mentioned, is to get relevant controls. It's how we did the hospital. We were talking about this on the side beforehand, how we did the hospital studies that got the FTC back in the merger game, hospital merger game. There are ways to study this. My point is that objective analysis, God forbid if there are people out there with the proverbial lamp who are objective still, but if somebody wants to make that big a move, the move from 4-3 being the marginal case to 6-5 being the marginal case, and that's a damn big move. If somebody wants to make that, I think they need objective data, and the objective data is there to be had. And I think, that if the agencies want to do a real service, that's what they ought to do.
That is a perfect closing comment for this panel, and I say that as an economist, being very much in favor of collecting and analyzing objective data. So I want to thank all of our panelists. This was as interesting a conversation as I hoped it would be. I want to thank all of you who are here in the audience and took time to come out and be here in person today. Everyone who is watching on TV, we used to call it TV. Thanks for watching. And we're done for the day. Thank you all so much. Thank you. That was good. Thank you both.